Hello everyone, it's Wayne Jones, the course coordinator for Statutory Interpretation. I'll say at the outset that you've got a nice easy week this week. This is often where statutory interpretation courses start. So they will often look at the common law and then take you through to where the law has developed to. But with your textbook, with the textbook by Michelle Sanson, I think she quite rightly, quite cleverly started off with a very brief discussion about legislation, etc., and then jumped into very early in the piece, well, this is the state of the law so far as interpretation legislation is concerned. Now, the material that we're looking at this week is in Chapter 9 in the text, and it is about, as I said, traditional common law approaches. But I think you're going to find that it's very compartmentalised, so I'll go through it and I'll tell you what I think you need to have a closer look at for this week. Generally speaking, we're looking at the common law as opposed to the statutory view of the world. And now remember, that takes us back to places like the interpretation legislation, Commonwealth and State. But a brief history of why there are common law rules, and more about that in a minute, is of course they came from a time when there were much fewer statutes. The law was much more common law based, and so there was more of an emphasis on the common law as the best means of interpreting legislation. Remember, Parliament continued to prevail over the common law, but because of that tension between the two, statutes were interpreted very strictly. So remember, just as a little reminder before we get into it and have a look at it, just do remember that the statutory rules still prevail. So we're still going back to section 15A, 15AB, etc. The interpretation sections that we've looked at so far, they still prevail, but here's some of the common law views of the world. And just a reminder, this is something I raised in previous weeks. The Act itself says that you're meant to confirm the ordinary meaning. Sometimes things can be ambiguous or obscure, when sometimes the meaning can be manifestly unreasonable. And you'll see those words now appear in the common law view of the world. Interpretation of statutes, of course, is still a matter for the judiciary. So here's a picture of Robert Fisher, our former Dean, dressed up as a judge, but the idea is that we're looking at common law approaches to statutory interpretation, because this is where the buck stops. When a piece of legislation needs to be interpreted, you still have to go to the court. A couple of examples that were great that were thrown up in the text as to when you really would head back to common law to have a look at the view of the world with these. There is still some effort, where more than one interpretation is open, to choose the one that's consistent with the common law. So put it another way, if you've got this whole raft of common law decisions in a particular area, then an interpretation, taking into account context, a good one is still going to be one that takes into account all that common law and doesn't try and fly in the face of it, unless that's quite clearly what the Parliament intended. And another one that I like, and we'll see more about this over the next couple of weeks, not so much this week, is still choose an interpretation that's more consistent with the principles of equity. And you'll see that gets expanded a little later on, I think in chapter, well, when we look at statutory presumptions, and certainly when we look at fundamental human rights. So they're weeks 10 and 11. Okay, the rules of, well, we'll call them rules for now. The rules of statutory interpretation are quite different to precedent, and your textbook, I think, makes the point quite well that context is everything. So consequently, when you have a decision, when you see a decision about how a particular section is being interpreted, it then doesn't bind the whole world of statutory interpretation. It becomes of persuasive value, as I think I've said in other weeks. Unless you had a decision on the exact same words interpreted by a superior court in pretty much the same factual circumstances. So we looked last week, I think, at that line of cases that troubles third-party insurers all over the place about buy-through, or in connection with a motor vehicle, or in connection with the driving of a vehicle. Just to make a point about that, for example, If you had exactly the same factual scenario, you'd be able to say, by looking at an earlier case, well, the law's pretty settled in that area. If the facts were different, even if you had a very strongly compelling previous decision about the interpretation of those words, if the facts are really different, then you start all over again, because context is everything. Your textbook gave you a great example as well, again from one of the cases that you looked at, that good reason in one act might not mean the same as in another. And of course that was the case which dealt with the Deputy Commissioner for Taxation and Clerk working out whether the wife had a good reason for not being involved in the running of the business. Look at Chugg and Pacific Dunlop. I'm not going to go into it now because this is not the time, but have a look at that. It's a pretty good example of the interpretive task of the courts in action. That's the case. That's the case, of course, where the courts were looking at just that really short phrase there, so far as is practicable, and just have a look for yourself and see the conclusions that they came to about how that should be applied, how that should be interpreted, I should say, and where common law principles were useful. So remember, provisions may be interpreted quite differently, and again, a comment from your textbook by Justice Hayden, that an acknowledgement that judges, individual judges, may look at the same phrase and come up with quite different reasons from time to time. And he's quoted there from the Victims' Compensation Fund case that we looked at in previous weeks. Do you have a right of appeal? Very good question, and of course the answer is yes. That statutory interpretation questions are questions of law, not of fact. So they're a really good ground for a disaffected party to litigation to appeal, and because they are questions of law and not questions of fact, judges in a jury trial. So let's think for a moment about a criminal law case and about, say, the meaning of manslaughter or even the meaning of murder. A judge will give a court a very clear direction about what the law is, and he or she will say, look, I'm the final arbiter as to what is the law, and I'm not going to tell you what the law is. These are the things you must find. So judges direct juries about what the law is. Great point made by the textbook, though, and bear this one in mind. If the judge's reasoning in a case is really clear, and the outcome, the statutory interpretation that you come up with, if the outcome is one that is open, remember that statutory interpretation is something that's discretionary, and that discretion won't usually be overridden. So I've been talking to students lately about the assignments that you're doing and about answers to assignments, etc. And really, I've always been talking about the prospect of coming up with different approaches, different answers to the statutory interpretation question. Just bear this in mind. If your reasoning is really clear and the outcome is one that is reasonably open under using statutory interpretation rules, then that's going to be fine. Because if you're putting yourself momentarily in the place of a judge, you've got that discretion. It is meant to be a complementary relationship between interpretation, legislation and common law. Your textbook has something to say about that, but I think that generally they're being a little bit generous. And so far as complementary is concerned, you certainly can find examples of where judges have referred back to the old common law approaches, if we call them common law rules, but the common law approaches. You can see plenty of examples of that. But realistically, I think that their use can quickly be overturned. So you could make a submission that such and such rule applied, but imagine these days, for example, trying to really push the literal rule. I think you'd have your work cut out for you. It is possible to apply the reasoning of the general law to a statute. Great example given, and so here was a case, Burns and Kendall, where the Trusts Act was silent on the sorts of things that a trustee could do with respect to a property, and so the judges felt really comfortable going back to the common law for reasoning purposes, to say, look, looking at this provision, It's a bit unclear as to what sort of powers the trustees have with respect to renting out the property. Look, the general law says this and this about trusts. Now, I've got to tell you, and I haven't got one handy I can wave at you, but trust me, it's a very thick book. The law of trusts has been around for a long time, and the law of trust is very settled so far as the common law is concerned, with some intervention from statutes in the last century. But there's a wealth of case law on trusts, and so courts don't have any difficulty referring back to that to interpret a piece of legislation. Is the authority of the common law a bit in decline? Well, this was a great case, also mentioned in your textbook, the Crown against L. This was the one you might recall where the husband was arguing that he could not be convicted of rape within marriage because a common law defence still existed. And so he was saying that by virtue of the fact that if you looked at the Family Court Act that says you could go to court and ask for an order saying, I no longer have to have sex with my husband, I no longer have to have sex with my wife. Pretty rare. I don't know that I've ever seen such an application, but such orders could be made. Then by implication, the old common law right to insist on sexual relationships within marriage must still continue. And thankfully, that argument was just soundly rejected by the High Court that said, well, if it ever existed, that common law defence has gone. So certainly common law is in decline in that sense. What are the traditional common law approaches? Look, these are the stuff of lots of textbooks. I'm going to go through them, but I would urge you to have a look at the examples that are given in the text for yourself in a bit more detail. And if you're really interested, excuse me, grab another text. I've mentioned to you previously that I refer from time to time to this one by Pearson Geddes, just called Statutory Interpretation in Australia, and it gives a bit more detail about some of the cases which are referred to in your textbook. My tip with respect to statutory interpretation and common law approaches, just have a short definition for each of these in your mind. Commit a short definition, and note at least one of the cases that I'll now mention for each of these rules and the Latin maxims. Are they rules or guidelines? Well, the answer is really they are simply guidelines, because the courts have always maintained the right to be extremely flexible when it comes to statutory interpretation. Alright, well here's an easy one because you've heard this many times before. Here's the literal rule stated straight out of the engineer's case, and this is not new to you. The fundamental rule of interpretation, to which all others are subordinate, is that a statute is to be expounded according to the intention of the Parliament that made it, and the intention has to be found by examination of the language used in the statute as a whole. So we've heard that before. In other words, look at the words given their literal meaning. It led to this. This is an example which is given in your text but no detail, so I'll tell you about it. In Higgin and O'Day, the language of the provision was just really badly drafted. Every person who I won't read the whole lot, but it goes something like this: every person who shall have or keep any house, shop or room or any place of public resort. So it's a pretty broad definition of the property that you keep. And who shall wilfully and knowingly permit drunkenness or other disorderly conduct in such house, shop, room or place, or knowingly suffer any unlawful games or gaming therein, or knowingly permit or suffer persons apparently under the age of 16 to enter and remain therein, or permit or suffer prostitutes or persons of notoriously bad character to meet together, blah, blah, blah. So in other words, it was meant to be dealing with a situation where, I don't know, pick one, there's a bawdy house and you let a 16-year-old in. But it was so badly drafted that the literal meaning meant that anybody who ran a shop that allowed a 16-year-old person to enter could theoretically be guilty, and so it led to a silly result and the law had to be changed. The golden rule, an exception to the literal rule, and it only applied if the result was absurd. And here was the good example that appears in just about every statutory interpretation textbook. The short version of Adler and George: it was an offence to obstruct a member of Her Majesty's forces in the vicinity of a prohibited place. and of course the inevitable happened. The obstructing was happened not in the vicinity, but actually in the prohibited place. And the argument was, well, the rule doesn't apply. The literal interpretation of in the vicinity doesn't mean actually in the place. And of course, the golden rule was applied, and the court found that in the vicinity of also meant to be in the place as well. The mischief rule, Hayden's case, it gets a mention, but you'll have to go scratching to find the facts. But essentially, it goes along these lines. There was a religious college called the Statutory, gave a tenancy which was subsequently dissolved by an Act of Parliament, and I think Henry VIII was in there somewhere. So it was. We're talking about a long time ago, and this must be perhaps one of the oldest cases that you've had referred to you so far. Was that an intended consequence? And the court came up with these. With this suggested approach. What was the common law before the making of the Act? What was the mischief and defect that the common law didn't provide for? What remedy the Parliament established? And how can the court interpret the legislation to give effect to the remedy? So this is really, I think, probably your objects, where we're up to with objects and purposes. It just looks and smells like it, doesn't it? Talking about objects and purposes. Why was this Act enacted? What was the legislature trying to do? So years when the literal rule created an ambiguity or an absurdity, but I think, and I think your textbook authors say the same, that it's now part of identifying the purpose of the legislation. So as I said just before I leave those three rules, they are rules in the sense that they're guidelines. They're not really rules, not hard and fast. Be able to speak to those three rules and be able to provide at least a case example of each one. Latin maxims. This is the first chance you get to use your Latin. If any of you have studied it, it's probably a bit rare, but anyway, nocitur. I'm just going to shorten these for the purpose of getting through this. Nocitur, it's known by its associates, justum generis, of the same kind, expressio unius, the express mention of one thing is the exclusion of another, and it's got a cousin, but just leave it with the one for now. Generalia specialibus non derogant. General things don't derogate from special things. The reason I'm sort of whipping through these is your textbook, I think, points out quite rightly the application today. Look, they are syntactical presumptions. So the courts can say, well, if I'm looking at the words, I always have to look at the words first. I know that's the rule. I can look at the words of the Act themselves. There's some rules of syntax that I could apply to come up with some presumptions about how something should be interpreted. But the overall meaning in the light of context and purpose takes precedent. So these are just some guides, some rules, but we're still going to go back to the context and the purpose rules over the application of the maxim. But they're still available to the courts to use. Nocitur then, an earlier version of the requirement to consider context known by its associates. Great case given there about the interpretation of what's a ship and charter party, etc. But essentially, you come at a meaning, a useful meaning for a word or phrase by looking at the words around it. Now remember, back from a few weeks ago, we talked about this. We talked about context. This is one I'd like you to pay special attention to because it does come up a bit, and it may even find its way onto to an examination because it's such a useful thing, this and its other cousin. A justum generis, a list of specific words in a statute followed by a general catch-all phrase. Then the general words are limited by the specific words. Good example, and one often used in questions is horse, cart, buggy, something or other, or any other thing. You're looking for some sort of commonality, I suppose, for the specific words. And if you can find that, then the or any other thing has to fit really within that. But really good example given in the textbook. That sounds so easy, really sounds easy, until you try to apply it to some specific things. And I think the example that was given was the one about phone devices. Imagine this: would apply on an aeroplane. Now, the hypothetical provision, it's an offence for a person to use a mobile phone, laptop, computer, Palm Pilot, or any other thing on board a flight. So you really got to work out what's the commonality, and they throw up quite rightly, I think, well, what about a Game Boy or some sort of toy that doesn't really connect in the sense that it's not a communication device? It's still electronic, but does it fit in? There is no answer, of course, but just making it clear that it can't always be the be-all and end-all. Have a look at Field and Gent. I think I'm going to talk some more in the Collaborate session this week about Field and Gent, but this is the one where the kids are playing with fire, and tragically one of the children throws some petrol on the barbecue, and the other child is injured. But to work out whether or not the injured child is entitled to some compensation, you need to work out whether petrol was a projectile. And I won't spoil the answer for you. Have a look at your textbook and see where the judge's reasoning took them. I just think it's an interesting process to go through, and you can see there'll be lots of opportunity over time for you to look at this aiustum generis rule. There are a couple of other case examples given in there, but I won't go through them now. But interesting one. Concentrate a bit of your time on this one because it comes up a lot. Expressio unius. The express mention of one thing is the exclusion of another. The easy to follow example. Only persons over the age of 18 years may enter. Well, you can assume from that persons under 18 may not enter. The case example is a good one. If you can appeal on grounds of law only, according to the legislation, then that will exclude appeals on fact and law. And it actually extends to process as well. So if a procedure has been designated, that procedure should be followed to the exclusion of other procedures. So if, for example, some jurisdiction, some body says this is the way that you deal with appeals from decisions from this tribunal, then you really should follow that procedure. Now that might be, and I think that an example was given of what would happen if there was a specific procedure outlined for appealing decisions about immigration, then you really should follow it, unless the two things that you're talking about are in the same paddock, but they're not exactly the same thing, in which case you may argue the contrary to say, well, hang on, that procedure that's been outlined really is about this. This is a separate thing, so I don't need to follow that one. So there's good room to manoeuvre there as well. Generalia, specialibus non derogant. General things don't derogate from special things. So in other words, when you've got something that's really specific, and you've got two provisions in conflict, the specific one is the one that'll prevail. Great example given, which makes it pretty clear. Imagine public, what do we call it, council rule number 1 about buses, no animals allowed on public transport. So there's your general provision. If you see another provision come along that says guide dogs, of course, are permitted on public transport, it's specific, it overrides the first one. So look, as an overview, what do I want you to take away from this week? Well, I think it's really nice, neat and easy this week. You first and foremost need to realise that these are now a little historical, and you need to think first and foremost about some of the steps, the processes that we've already talked about over the previous 8 weeks before you'd even start to throw around these common law rules. But if they are of use, and there are lots of examples given in the textbook, if they are of use, a judge is perfectly able to refer back to the common law rules to say, well, the rule more or less should be this. And you'll see an example there even of the use of the literal rule to try and work out what the proper meaning of a statute is. So they're available, they're part of what a judge can do, but they cannot overrule these days where we've got to with the specific interpretation legislation about looking at, give the words their ordinary meaning, taking into account their context, and also thinking about the purpose of the act. That's going to be your common thread. That's going to be what you're always going to come back to. And all of these, you should now start to be getting a feeling in week 9. All of these other rules really just are other tools in the toolbox that judges can use to assist. So look, have fun reading that. Make sure you do get those couple of cases down, Pat, but don't go into too much detail about these. Just get a feel for how each of those rules worked, and I think that'll be sufficient. Thanks for listening to me. I'll be back again next week to talk about Chapter 10 in our text, and that is some statutory presumptions, and I think you'll find that quite interesting. Thanks very much.